Welcome to Frankly Speaking, the podcast on responsible business from Frank Bold, the European public interest law firm. I'm Richard Howitt, and after many years leading on responsible business issues inside the European Parliament, I host our discussions about the latest developments in corporate sustainability, sustainable finance, business and human rights. Today, new human rights and environmental due diligence legislation is coming in across Europe, but the German Supply Chain Act, LkSG, has been in effect for more than 3 years. We discuss what has been learnt from its operation. My guests to discuss this are Finn Schufft, Policy Advisor on Corporate Accountability with the NGO Germanwatch. Finn is author of a new study, The Impact of Due Diligence Legislation, undertaken by Germanwatch in conjunction with the German Catholic Development Organisation Miserere. Alongside Finn, we also welcome Emirali Karadoğan, researcher and trade union expert for the Tez-Koop-İş trade union in Turkey, one of the subjects of the new study. Welcome, Finn.
Thanks, great to be here. Thanks for having us.
And welcome to Frankly Speaking to Emirali.
Hello, great to hear you. Thank you.
Now, Finn first. Let's just have an overview of your report's finding. What has been the main impact of the German Supply Chain Act?
Yeah, so maybe going back a bit on the German Supply Chain Act, maybe it's useful to put it a bit to context. I mean, the German Supply Chain Act was adopted in 2021, entered into force in 2023. And I think, it came into being very much in a context set on the one hand by the UN Guiding Principles on Business and Human Rights, obviously, and their implementation, or rather lack of implementation in Germany. But it's also a law, that was supported by a very broad coalition of civil society organizations, church organizations, trade unions, academics, lots of companies. And obviously the support was driven, by the awareness of human rights violations occurring in the value chain of European companies. And this ultimately led to a law being, tabled by the government. And obviously ever since then, since this was one of the very first laws of this type, alongside the French duty of vigilance law, of course, as sort of the other, broad due diligence law in Europe, the question always, of course, was, so how does this law play out in practice? Like, does it work as intended? And of course, an important part of the, campaigning by certain business associations against this type of legislation and against this law in particular has also always been to say, it's an honorable goal, but these types of laws simply do not work out in practice. They are overly burdensome for companies. They don't really produce any real impact, or if anything, they might even be making things worse. And I think one very clear outcome of our report is there are numerous examples where the law is producing precisely the impact that it was designed to produce. So to counteract the diffusion of responsibility created, I think, partially by design, through the complex corporate structures and long value chains that we oftentimes see. And I think the way the law does this is by making big companies in Germany directly responsible for using their leverage. We have a number of examples of this in the report, from the transport sector in Europe to the fight for freedom of association in Turkey, which Emirali will be able to say more about in a second, to the remediation of environmental impacts of the mining of mineral resources in Guinea and Western Africa. So there are clear examples where this law is having an impact, and I think that's one important first outcome of our report. But I think it's also obviously not as simple as to, simply say this law has an impact or it doesn't have an impact. I think the question that was, and I think continues to be, most interesting to us is not only if the law has an impact, but also how it works, under which circumstances it works, and which factors play a part in contributing to its impact or in impeding greater impact. And we tried to get some very first, admittedly, answers to these questions by talking on the one hand to companies applying the law directly in their everyday business, and importantly also to civil society actors and trade unions working with the law as a tool to defend their rights.
And just to help our audience, you're saying it's got an impact, but just give us some examples of that impact. Perhaps not the Turkey example, which we're going to come to, but from the others.
Right. Yeah, so for example, this is, I think, a particularly interesting example is the street transport sector in Europe, because oftentimes I think when we talk about these types of laws, people think of, impacts that are somehow removed from Europe, but actually we see that this law is having a big impact when it comes to the transport sector in Europe, where we have, really, I think, catastrophic exploitation of truck drivers happening on an everyday basis, basically, on German highways. And the way this works is that German companies sort of try to delegate responsibility, shift away responsibility through complex structures of subcontractors that through which truck drivers are employed. And I think what we see is that the German Supply Chain Act really cuts through these sort of opaque networks and opaque subcontractor structures and puts responsibility with German companies. And this has been used by truck drivers in Germany, for example, to bring cases where they've been withheld wages, and it has been successful. They've used this law to activate, so to say, German companies to use their leverage to exert pressure on companies that deliver goods for them on German highways.
And we can't use them all, but I was very impressed, whether it's banana production in Ecuador and Costa Rica, mineral extraction in Guinea, Morocco and Peru, land grabbing in Honduras, Xinjiang in China, forced labour that many of us know about, textile production in Pakistan and Bangladesh. These are the examples that you look at in detail in the report. And even though I think many people listening would say they're pretty intractable problems that it's very difficult for companies to influence, in each case you show how that influence has been at least partially successful. So it's really interesting findings. Now let's come on to Turkey and to you, Emirali. Tell us a bit about the challenges in the supply chain of German companies that you've been trying to combat.
Thank you for the question. When we talk about working conditions in Turkey, it's important to move beyond a narrow understanding limited to wages or working hours. The core issues we are addressing is the systematic erosion of the workers' collective rights, particularly the right to organize and organize collectively. At the workplace level, there is a deeply entrenched and anti-union environment. Workers are frequently subject to intimidation. They are threatened, sometimes explicitly, sometimes indirectly, dismissal if they join a union. In many cases, this pressure leads to forced resign from the union membership. What is especially concerning is the level of the direct employer interference in unionization process. Workers are not only monitored, but in some cases, they are asked to prove whether they are union members, including being pressured to log into personal system, because the member system is personally direct to our labor minister. This like a online membership. For this one, they ask to our member and log into the personal system. This creates an atmosphere of surveillance and fear, which fundamentally undermines freedom of associations. Secondly, there is a consistent pattern of the relations. Workers who support unionization are often targeted. This may take the form of dismissal under fabricated reasons, reduction in bonuses, worsening of the working conditions, or increased workloads. Even individuals in the managerial position are not immune if they are perceived as supportive of union activity. They can also face dismissal. A third one, and particularly troubling dimension, is the targeting the vulnerable workers. And we saw this one at the German-based company also at that time. In the case, represented workers affected by the devastating earthquake. As you know, people who had lost family members, homes, and were living in the temporary shelters were subject to additional pressure. Their economic vulnerability was used against them. They were effectively told that maintaining their livelihood depend on the union. It's not only the labor rights issue, it's the profound ethical issues. Finally, there is a structural and legal dimensions that enforce all of this, the obstruction of the collective bargaining. Even when a union reaches the legal threshold required for recognition, employers can use legal mechanism to challenge this status. This is the big problem in Turkey, is faced of the trade unions. This legitimate legal rights, yes, we on the paper, we have the constitution, we have the other rights, but in practice, it's widely used as a union avoidance strategy. Court proceeding can take years, sometimes up to 5 years more. Court proceeding can take years, sometimes. The other hand, during this time, collective bargaining is suspended and the union strategy is gradually eroded. Workers lose confidence, membership declines, and by the time a final decision is reached, the opportunity for the meaningful collective bargaining may already be lost. So what we are facing is not series of isolation violations. It's a coordinated and structural pattern of union boosting, supported by the institutional weakness that allowed its to persist. Because we have to know this situation in Turkey, at that time we can understand the due diligence or the other international maybe accords.
Let me come on to that. And clearly what you've said is it's a basic freedom of association that trade union recognition is so difficult in many instances in Turkey. But as you say, the German Supply Chain Act for due diligence wasn't understood, but
yeah.
you did, and your union did come to understand it. How did you use this to your benefit?
Okay. Due diligence legislations gave us a way to move beyond the limitations of the national system. It's important for us and for the trade unions. However, to understand how we use it, it's important to underline the scale and nature of the violations and obstructions of freedom. Beyond these direct violations, the company also used legal procedure tools to obstruct workers' rights after the union reached the legal thresholds. And faced was not only the right violation, but also deliberate strategy to delay victim and ultimately prevent unionization. In this context, due diligence legislation become a critical tool. Our international trade union organization, Global Union, regularly brings together it's a place to discuss challenges and developments in working life. In this platform, due diligence and its implications for trade unions' rights were discussed extensively, and we applied this knowledge in practice during our organization efforts in the German company. We relied on the German Supply Chain Due Diligence Act. First, we formally notified the company of the violations and provided documented evidence what the law defines as a substantial knowledge. We clearly called on the company to investigate the situation and take the corrective action. However, the company's management in Turkey denied all allegations and refused to engage in dialogue. At that point, we escalated this issue to international level. We worked through Global Union and German Union Verdi to reach company headquarters in Germany. Verdi expressed its solidarity through unofficial letters, which also made public in Turkey. We also made it clear that we reserve the right to file a formal complaint with the BAFA, the German Enforcement Authority. At the same time, through press release and union actions, we continuously keep the public attention and the company's failure to comply with both national and international labor standards. For all procedure, we deal with the due diligence rights and the due diligence law at the supply chains of the German Act. Important situation began with shift when due diligence became a central issue and international pressure increased. The employer who had previously refused dialogue eventually called on the union to negotiate. In this process, Global Union, Commerce, and Verdi played a crucial role. And we would like to acknowledge and thank them. Also, Matthijs Balten and Onur Bakır also, it's very good. They did the good work. So in practice, due diligence legislation become a tool for transnational pressure, enabling to us hold the parent company accountable when local mechanisms prevent ineffective.
Where the Turkish companies were rejecting your claims for workers' rights when it was escalated with the international trade union federations that you referred to customers in Germany, business customers, then suddenly it was taken seriously and the rights were won. I wonder, Finn, what did you learn from that example?
Well, I think it's an example that really is the perfect illustration of, I think, one aspect that is consistently shows in our report is central for the success of these laws, which is, I think, a strong network of trade union and civil society organizations. And I think that's an enabling condition for this law from a rights holder perspective that oftentimes gets overlooked, right? I mean, I think we see, the case that Emirali just described, we really see how, Tez-Koop-İş in Turkey worked together with international trade union networks to sort of exert the pressure that ultimately led to this case of, actually impact of the law. And I think, there's numerous ways through which the law can work. I mean, there's an official complaints procedure, but if we look at this type of sort of pressure being exerted from civil society or from trade unions, I think we really see that, an active trade union like Tez-Koop-İş in Turkey that I think really importantly also knows about the law and knows how to apply it in principle and is supported by international networks. That's really, I think, as I said, like an important sort of enabling environment for the law.
Now, Emirali also talked about BAFA, the German supervisory authority, and any law is only as good as its enforcement. What conclusions did you come to about how the German Supply Chain Act was enforced?
Yes, I think that's another really central aspect of our report. I mean, I think it's important to understand that, unlike the French law, for example, the German law does not stipulate explicit, access to justice by way of civil liability under the law. So the main avenue of redress for rights holder really is through this complaints procedure established by the BAFA. So that's a really important mechanism for the enforcement of the law, along with the overall obviously control and enforcement that BAFA carries out under the law. And if we look at this complaints procedure, I mean, according to official data provided by BAFA itself, there have been hundreds of complaints submitted to the authorities since the law came into effect. And yet, if we look at the cases in our report, none of the positive impacts of the law on rights holders that we know of have been achieved through this complaints procedure. So I think that's one of, many indications that there is severe flaws in the enforcement of the law. And I think this may, in the medium to long run, this may be the biggest risk to the effectiveness of the law, because as you said, laws are only as good as they are effectively enforced.
Now, many of our listeners will obviously know that CSDDD, Corporate Sustainability Due Diligence Directive, is going to replace the German Supply Chain Act. What's the comparison between the two, and what do the stakeholders in Germany say about what's going to happen next?
So looking at the timeline, I mean, obviously the German Supply Chain Act was adopted before the CSDDD. I think the two laws have a similar approach in many ways, because they're both obviously somewhat modeled after the UNGPs. The CSDDD is in part also modeled after the German law, I would say. And looking at the, sort of the situation in Germany, the German government has agreed that the German law will be replaced or amended by the law that will transpose the CSDDD in Germany. As we all know, this has to happen until July 2028. We don't know yet of the time frame set in Germany for transposition. And I think one really important aspect of this transposition process, and I think an important aspect also when we look at the relationship of already existing corporate accountability due diligence laws with the CSDDD is that it's really important that the level of human rights protection afforded by the German law must be kept. So there's the so-called principle of non-regression that's established by the UN Covenant on Economic, Social, and Cultural Rights. There's a similar, slightly different, but similar principle in EU law. And this means that I think, probably most obvious example for this is the scope of the law, so how many companies are actually covered by this law. If we look at the German Supply Chain Act, it only covers very big companies with more than 1,000 employees, but it is not as narrow in scope as the CSDDD after the Omnibus. So if we look at German companies covered by the law, for example, if we apply the scope of the CSDDD, this would mean that only 5% of the companies currently covered by the Supply Chain Act would then be covered by the CSDDD.
Just to make that clear to listeners, the German Supply Chain Act applies to 2,900 German companies. CSDDD scope would say it's reduced to 150, so you can see how dramatically different that is. I'd like to come back to Emirali now. You're a trade unionist. Trade unions have used the International Labour Organization, ILO conventions. You've used local labour laws. They exist in Turkey and exist in states around the country. You might well have used the national contact points of the OECD multinational guidelines. So you've got mechanisms to try and enforce good labour standards. What is different about due diligence? What is additional that you found useful?
I think it's a critical question because generally when we organized, we are using ILO conventions, OECD guidelines, and the other international guidelines or conventions. But due diligence legislation represents a very important development, but it should be understood in relation to existing frameworks. Local labor laws in Turkey do, in principle, provide protections. The legal framework recognizes freedom of associations and collective bargaining. However, as mentioned earlier, there are serious structural gaps in enforcement. Legal procedures can be lengthy, and certain mechanisms, such as objections to union recognition, can be misused. For instance, ILO conventions, particularly conventions 87 and 98, set very strong and widely recognized international standards. We know that they are essential as normative frameworks. However, their enforcement mechanism rely largely on state reporting and international supervision, which can be slow and indirect. This is important because this is the indirect. OECD guidelines are also important, especially in the context of the multinational enterprises. But again, they are not binding a strict legal sense. This is the critic sense is this one. What due diligence legislation brings is something different. Binding obligations combined with enforcement mechanisms. It creates tangible consequence, legal, financial, and reputational for the companies that fail to respect human rights and their operation and the supply chains. This is the important things. If they don't obey this due diligence law, they are faced with the high financial punishment. This is the critical for the companies because trade unions want to get some benefits, earn much money for their members. This is the money. This is when they faced with the punishment as a money, as a financial, this is the critical and this is the binding factor for this due diligence is important. In that sense, it represents a shift in the balance of the power. It moves part of the responsibility and accountability to the level where strategic decisions are made. Also, however, it's important to emphasize that due diligence is not a magic solution. Its effectiveness depends on how it is implemented, how it is enforced, and whether workers and trade unions are actively involved in the process. its real value lies in the ability to connect international standards with real-world enforcement. For this is the ILO conventions, OECD guidelines. Yes, this is the good mechanism, but the diligence law is more effective than for the trade union, the others.
And it's that binding nature that you particularly refer to, and that in a country like yours, where you say that trade union and workers' rights are not well respected and enforced, that it overcomes the problem of the difficulties with the state by enabling you to leverage business. Finn, in your report, you give some really positive examples of impact, but you also have findings that 1 in 3 companies in Germany only use software and desk-bound analysis. They're not actually engaged with local actors. And you say between 50 and 80% of companies with global supply chains say they don't have any human rights risks at all. And you very moderately call that, quote, questionable, unquote. What did you conclude when you found those fairly sobering figures, let's say, in terms of how we should move forward?
I think this points once again to the central role of the law being properly enforced. I think, I mean, you know, this was a survey done in the, I think, second year of the enforcement of the law. The supervisory authority in Germany, the BAFA, is openly admitting that it's taking an approach of dialogue with companies rather than sort of exerting its full spectrum of potential enforcement instruments at the moment. But I think it's really time now, after 3 years of the law being enforced, that we move beyond this approach. And I think if the BAFA does not move beyond this approach, we risk seeing this sort of compliance tick box approach that I think is reflected in those figures that you just quoted. We risk that taking over even more. We risk companies sort of perceiving this law as less binding than it actually is. I think the main sort of advantage of this law that Emirali just described is its binding nature. There's a real coercive force behind this potentially, but it needs to be used. And it's obvious that the law will not produce or will not realize its full potential unless those enforcement instruments are being used.
Emirali, we've been talking so far about European legislation being complied with by Turkey and Turkish business. But I know that in Turkey it's an important medium-sized company, lots of economic development, that there's also debates within Turkey and within Turkish companies about responsible business, about net zero, about sustainability. Just give us, as we've got you with us, just give us an idea how advanced those debates are in Turkey and with Turkish business.
Thank you for this question. This is because we are using some conventions, some international law at the multinational companies, but we generally face with the local companies in Turkey. The concept of the responsible business conduct in Turkey is evolving, but it remains incomplete and unwellly applied. There is growing awareness, particularly among companies that are integrated into global markets. International frameworks such as OECD guidelines, ILO standards, and EU regulations have made an influence. However, in many cases, responsible business conduct it's still approached as a matter of the formal compliance and the corporate image, rather than as a deeply embedded practice. There are also structural barriers, weak enforcement, long judicial process, and misuse of legal mechanism all limit the practical impact of existing standards. As a result, we often see the responsible business conduct remains service level. It is driven by external pressure and does not sufficiently address core labor rights, particularly freedom of associations. There is also significant contradiction. Many Turkish companies publicly declare their commitment to the United Nations Code of Conduct Principles. As you know, this is important for OECD guides. These commitments are visible on websites and in corporate reports. However, in practice, compliance with this principle is often limited. In some cases, companies apply these standards more rigorously when operating abroad, using them as a part of their corporate social responsible strategies. Yet in their domestic operations, the same standards are not consistently upheld. This gap between commitment and practice is one of the central challenges. And looking forward to the development of the responsible business conduct in Turkey will likely continue to be driven by external dynamics, like maybe the other conventions, international regulations, laws, and global union engagement. But for this concept to become meaningful at the national level, there needs to be stronger enforcement, more binding obligations, and the active involvement of the trade unions as the case stakeholders. This is generally we can say, yes, they have some code, like a code of conduct, but they don't willing to use for the labor rights or the trade unions' rights.
Yeah, it's a challenge. I've myself worked with CSO Turkey. I've also with the Al Gudin Institute in Turkey. So there are advocates within the country that are trying to change that. But I think you've suggested it's a long way to go. Has to be the last question, Finn. Really excellent piece of research. I congratulate you on it, and I hope people will read it. But what would be, particularly as due diligence legislation is coming in Europe-wide, not just in Germany, what would be your message across Europe from undertaking this study?
Thanks very much. I think our message really, number one would be keep a close eye on the supervisory authorities, make sure they keep a close eye on companies, not only to create pressure for companies to get active, but also to ensure that the laws applied correctly and not with a compliance tick box mentality. I think my second message would be don't lose sight of the enabling conditions of the law. So it's essential really to enable rights holders to use the law, to make the channels of redress as accessible, as transparent as possible, and to really inspire trust in these laws and to with rights holders. And then finally, I think the main message really is treat this legislation as a strength and not as a weakness. And I think this obviously also goes to policymakers because, I think what our report shows is that you can speak, openly and self-confidently about these laws. There's good indications that they do actually, work and have a positive impact. And honestly, I've never really understood why the German government has not promoted this law more openly with partner countries, because many people in the world suffer from unchecked corporate power, and many of these cases can be traced back to Europe. Many others obviously cannot. But to show that this is possible, to provide a real effective accountability mechanism, I think this can also potentially be a reputation booster for Europe, right? And I think especially in comparison with other economic superpowers increasingly acting with ruthlessness and brutality and becoming less reliable as partners, I think this is what can and should set Europe apart, really.
In this podcast, we've heard that the sorts of abuses that are dealt with don't just happen in faraway countries. So the Rollhauliers not paying their lorry drivers in Germany was an example of getting that rectified. But we also heard the example from Turkey, from Emirali, who showed how by escalating up the issues, not just to the management of the Turkish-based companies, but to their business customers in Germany, that made a very, very significant difference. We heard that the CSDDD will pose a threat to some of the gains that have been made under the German Supply Chain Act, but perhaps the principle of regression may be applied in Germany and elsewhere. We heard from Emirali about how Other mechanisms for safeguarding workers' rights are there, but they're not binding, and there is more of a balance of power in the way that the Supply Chain Act has been utilised by Turkish workers working in cooperation with the German and international trade union federations. The position in Turkey itself is very much based on external pressure rather than necessarily advocacy within the country. The United Nations Global Compact remains the most important set of principles that are referred to by businesses there. And we heard in that last answer from Finn how enforcement is absolutely crucial, that it's the complaint system has been widely used under the German Supply Chain Act, but could have been used more. And he said, don't underestimate the enabling powers of due diligence law that don't alone require on the supervisory authority. The study from Germanwatch on what is the impact of due diligence legislation is available to download from the Germanwatch website. Sadly we have come to the end of our podcast, but I'd like to thank very much Finn Schufft and Emirali Karadoğan for joining us.
Thank you very much. It was great.
Thank you very much.
You've been listening to Frankly Speaking, the Frank Bold podcast on responsible business. Find out more about Frank Bold's Responsible Companies section on our website, and please give us your feedback on our LinkedIn page or by commenting via your podcast provider, where we hope you will share this conversation and give this podcast a 5-star rating. And remember, you can watch us on our YouTube channel too. Thank you again to Finn and to Emirali, and to all of you for listening. Do join us next time.